Hi, this is Earl Knudson with some compliance updates, and we'll look forward to a few of the recommendations for 2020. So we have some issues we can cover. At the same time, I'll try and make this as short as possible and get right to the point, the RPA, so that you can go about your day. Let's start right at the top of the page, number 2 on the contract. The paragraph number 2B specifically is confirmation. We're still seeing a lot of files that don't have the confirmation filled out with all 4 items: the seller, the buyer's agent, the selling office, and the license number of each broker. All 4 items for both agents, and check the box. Whether you represent the buyer as a co-op agent, you represent the seller, or do you represent both, meaning both agents somewhere actually work under the same broker and they're a dual agent in the state of California. This is replacing the AD3 from 2018, and this paragraph, number 2, is not optional. Since it's an actual AD form, this has to be filled in by law. This is not an option, and it's critical that you always have an agency form. Keep in mind, agency forms, if they're not done before a transaction or during the presentation of the transaction, it's an equivalent, no agency, no commission. And what the CAR means by that is that it is civil code, it's law in the state of California. Every transaction must have these agency forms. Without agency forms, you're not entitled to a commission. It's actually illegal. So you may get paid out of escrow, but if a client ever decided to challenge it, they would win because you defaulted and didn't obey the law when you did your agency. So that's how serious these issues are, and we don't need to go into it further. You've got 4 aspects that have to be done. Do them all, and don't forget to check the box. Also, number 3 is becoming very critical. Number 3 has been ignored for many years because only offers with FHA or VA normally do the agents fill out the interest rate and how many points. These caps protect those buyers that may apply from VA or something of that sort. But actually, these items show that you are competent in writing a real estate contract. This is a very important point because, yes, you can put a 5% cap on the interest rate and 1 point, even if it's a conventional loan. It's not required to put that information in if it's a conventional loan. But it also shows that by not leaving it blank, the agent is doing their due diligence and they know how to write an offer. And these points are points that lawyers are exploiting in lawsuits against agents and firms, that they're not competent in writing an offer. If at any time an agent is proved to not be knowledgeable of an offer, whether it comes out from their a lawsuit or even just a deposition before a lawsuit, a judge can set aside the contract in court. Basically, it can be voided almost immediately if the judge believes that, yes, the agent didn't understand the contract when they wrote it. So please be careful with page 1 on all the items. Moving along, normally with cash transactions, it's very impressive to remove the contingency appraisal, contingency for the appraisal, because they're going to get a loan, no loan. And don't do that. The CAR attorneys are recommending that you just don't do that. You don't take away even a cash buyer's right to at least have some sort of contingency period with the appraisal. So please don't check that box that there's no appraisal contingency. Just present the cash offer. Okay? Speaking of cash offers, you also have to make sure that your buyer is bringing in foreign funds, that you have them talk to their accountants. And if a seller, if you're dealing with a property that might be over $2 million, remember to advise the seller to talk to their accountant regarding foreign investment. They may be have 15%, as much as 15% withheld from the escrow of their proceeds to make sure taxes are paid. The entire process can take as fast as 4 months if they talk to a lawyer and an accountant in advance to selling the home, or if they don't and they wait till post-escrow, it can take up to 1.5 years to probably get their money back. So these are things to consider all the time. Okay, and make sure if you're using, these came out last year, the SPRP and the COP. COP is a buyer's contingent, SPRP is a seller's contingency. A lot of agents are using just an addendum contingent upon the sale of their property and the purchase of their new property. Please use the proper forms, okay? The forms were brought out and they will cover the liabilities involved in those situations. Also, 10E mentions the radon, gas, and mold, but it would be so much better on all your files if you just use zip forms, RGM. You are familiar and you're already using the RGM, the lease form, but there's the form for the sale. And the one for the sale is not required by CAR, but it's really an important form because it's a release of liability for the agent. So it's not just disclosing there may be mold, that's not the situation. RGM is for any agent, whether he's listing or sale, and it's a release of liability about mold issues. So that's also very important, okay? I want to talk about liquidated damages just for a moment. Liquidated damages, some of you are forfeiting very large amounts of deposit if you're canceling after the contingencies are removed. That's not specified in liquidated damages. It just, liquidated damage is a cap on how much can be forfeited. But actually the law, if you ever went into court on a dispute of that kind, or a small claims court, a judge is going to really want to see damages like lost rent. So even if you remove contingencies and something falls through on the financing or something else comes to the surface, don't assume just because maybe the listing agent says you have to forfeit the whole entire deposit that that's entirely true. It is negotiable. It's got to be by mutual agreement. There's no set amount, okay? So always fight and try and protect your buyer's funds and let your sellers know that that's what's going to happen. It's got to be by mutual consent. It's not automatically their money. The date of your offers I'm seeing vary. It is not the date at the top on the left side that when you wrote the date of the offer, the sale that starts the contingency period is determined by the last person who signed. Hopefully, you're having everyone sign the confirmation of sale. So if it's a counter offer, the BCO, the buyer's counter offer, it goes back to the seller and the seller is signing it. Yes, I confirm that I know that I've sold to this buyer. But whoever signed last, that's the date of the start of the contingencies. Okay, so if that becomes an issue on sending it out, you're highly recommended right now, if you are a listing agent, to send out the CR 2 days before the contingencies are expired. So if the contract is 17 days, you should send out your CR to the buyer from the seller on the 15th day. Please go and talk to the agent before you do this. Let them know your compliance officer has required all listings get the CR sent out before the expiration, because a listing agent, if they don't send out a CR on time as specified in the RPA, could be doing his seller a disservice. So you can't not do your job. If the other side says, hey, we're doing everything, we're on time, you just explain it's nothing personal. We just enforce the time periods and we alert to people of time periods in all our contracts. That's why they're there, and it is specified in the contract that there will be a notice. So I would like our agents all to send out the CR and make sure it gets done. The other major thing is I'm seeing very inefficient or no AVIDs. Well, let's get something really clear really fast. Is by law you are required to do an agency form, and you're also required to do an updated agency form at the time of presentation, which is 2B on the offer, number 2B, letter B. But if you don't do an AVID, you are also in violation of the law. It is certainly the buyer's agent must do an AVID. I have heard agents say the property is in another county, maybe it's in Northern California. I can't get out there. They just asked me to write the offer for them. The DRE expects you to learn about the property. Do some due diligence. They expect you to educate your buyer. Every time you learn something, you disclose it. And the AVID is at a level of the TDS, and you know that's required by the seller. So please do a walkthrough, do an inspection, take pictures with your phone, make notes in your phone, even video it in your phone, but make sure that you do a comprehensive inspection on things that you know about, not as a contractor, not as a repairman, but as an agent just checking for anything that might be a red flag that you may want to have them consult a contractor or someone who specializes in the field, or any stains or anything. We can't define what they are, we can't say they're mold, but if you notice them, put it on the AVID. The other thing that I wanted to, speaking of which, on sellers, sometimes all of you are really using the RCSD now really well. If you have a corporation, we're getting a lot of RCSDs. But there is still some confusion on who does a TDS, who does not do a TDS. Well, the living trust is not an exemption to break the law and circumvent disclosure laws that I have a trust on my home, I'm not going to do a TDS. No, it doesn't work that way. You got to be dead. And that's serious. Because if you are a trustee of a property and you are the actual beneficiary and you're selling the home, if there's more than one trustee authorized to sell the property, both will have to have their signature. They will do the RCSD, sign it as trustee. But if the trust is owned in by the owner, is living in the property, and is currently there living when he sells the property, he is required to still do a TDS and SBQ. I've heard everything the agents say. The seller doesn't want to do one, he owns it. Please, just refer to the CAR website. You have to do a TDS and an SBQ if you are the trustee and you're living in the property. If the trust is not lived in by the owner and the trustee doesn't occupy the property, then the trustee would do a TDS still again, but they can do an ESD in lieu of an SBQ. But there's a minimum of 2 years that not living in the property. Now, if the trustee has died, then only the ESD is required. So, and you'll find all this information on the TA. A TA always is signed by buyer and seller on any transaction that has a trust, okay? So those are your points that I most commonly see in the file, and some things that you should be aware of in 2020. Enforcement of the contract is real. Not doing an AVID, not doing your work on the property could lead to a breach in the actual contract. If you have to do an addendum and you're not going to close for 45 days and you know your escrow says 30 days, you have to do an ETA. You know about your ETA, go ahead and do it. If you need someone to perform, send out a notice of buyer to perform or seller to perform. These are now integral parts of the transaction. They came out in zip forms as optional, but what they mean is when necessary. And even if the escrow goes beyond the 30 days, 1 day, technically, both principals, they're in breach of contract. So be very, very careful that you don't lead to anything that could lead to a breach in contract. That's it.